right, you may proceed, Mr. Ridgway.
After you've found the aggravating circumstances and determined the mitigating circumstances, and you've weighed them one against the other, and you find that the aggravating circumstances do outweigh the mitigating circumstances, you still have to decide that the death penalty is the proper sentence in this case. And the question then becomes for you, is this that case? So why should you? The why is in what? What Markeith Loyd did, what he did to this person whose life he took. He took the life of her unborn child. She was his mother. She was the sister of Ronald Stewart, whose life...
Sustained. Jury is to disregard the last statement. You may proceed.
You also found the defendant guilty of the murder of her brother, the attempted murder of her brother, Ron Stewart. And you also found him guilty of the attempted murder of her brother, Dominique Daniels. And you also found him guilty of the attempted murder of her mother, Stephanie Dixon Daniels. When you consider the enormity of what he did, it far outweighs any mitigation. And if the enormity of those actions don't make this the proper case for a death penalty, then what would?
Thank you, Mr. Ridgway. Mr. Lyman, you're closing?
Thank you. Morning. There are moments in our lives when we get to step into the light. This is one of those moments. Markeith Loyd will die in prison by your verdict, life without the possibility of parole, by your decision today if you choose life for Markeith. He's never getting out. You know, because you were told over and over again, this case is not about Sergeant Clayton. There is nothing today in your decision that can be used in any form or fashion in regards to what happened to Sergeant Clayton. This is about Sade Dixon and the 2 to 3 month old fetus that died when she was shot. And over the next hour or so, I'm going to talk to you about what I believe the truth is, what the evidence has shown, what the testimony brings to you, why this case, without question, will require only one verdict in each of the cases, and that is life. Why is it supported by the evidence? And why, as you listened to this case from beginning to end, now you get to determine what's important to you individually. Now, I won't shade issues. My client testified. He gave a version. You rejected it in some form or fashion. Your truth of what came from his testimony is your truth. I'm not going to step on your truth, whether I agree or disagree with it. What I'm going to show you is with your own truth, the truth that you found from the verdict, the 13 seconds or so that occurred from the time that Ms. Dixon said, my brother's going to kick your ass, till the time that he's leaving, is the time of focus for you when we're talking about my 4 experts, their testimony, the history of my client, and the circumstances that led to the moments that we are here about. So with your own truth, assuming you believed everything that was said from the Dixon family, and I'm not going to step on that, and from Ronald, that even under those circumstances, the evidence here supports a state of mind that is consistent with someone who has delusional disorder and post-traumatic stress. Now, you didn't know about that when you heard it, and you wouldn't have, because as you heard from Dr. Mayer, this never would have been an insanity case. In Florida, insanity means that you don't know right from wrong because of a mental illness. And he told you some examples of how that plays out. Here we have a situation where there's no question Markeith goes over there. There's some kind of conflict that occurs before. There's a period of time where it appears that they don't even dispute that she goes in and retrieves a firearm and comes back outside. And there's a period of time, whatever you believe the facts to be, Markeith or otherwise, that he ends up with her gun. And then there's a period of time that her brother comes out and she makes that statement. My brother can kick your ass. So that's where we are when we begin, under a microscope, what is going on with Markeith. Before I get there, I want to talk a little bit about what the prosecutor said. You can only rely on your facts, your memory, what came from there, what happened before at the trial. You have the absolute right to reject whatever I say and to reject whatever he says. And I would suggest for the last 45 minutes, the only person with more hot air in this room than this prosecutor was Dr. Pritchard. Because they set it up so it could be a personal responsibility issue. That's why this doctor who rides the circuit for the state of Florida, who claims that, yeah, he got rid of a case for Mr. Buxman. What was the case? Was the guy totally retarded? Was it so extreme that they should have never even thought about death penalty? Do they look to this doctor to make decisions that the prosecutor, Mr. King, I don't see him in here, should be making about life or death? This is not even Mr. King's jurisdiction. Mr. King's over in Marion County. But he comes over here from Markeith Loyd, and that's why we're here today. But I would suggest that what he said over the last 45 minutes were half-truths. And I'm going to give you what I believe the truth is. You decide. And let's start at Markeith being 7 years old. Being raised in Carver Shores with a single parent, a mother who struggled, a mother who herself was a victim of domestic violence, from a father that he never knew. Now, as we take this journey, it's important to remember that when you're thinking about mitigation, and the aggravation, and I'm going to explain this in more detail when we get towards the end of the case, that you get to look at the aggravating factors, and I am not disputing that these aggravating factors weren't proven. I'm not going to waste your time. He was convicted of this battery of a law enforcement officer. He was on probation after going to jail for 14 years, 16 years, whatever the case is. And when he got released, the 2 years leading up to this event where he was doing what he could do, not committing new law violations, not getting arrested, not selling drugs, not doing any of that, he was on probation at the time of the event. Those are proven. I'm going to talk to you about how weight plays into those things in your decision-making process. And as importantly, which he didn't really explain, sufficiency of the aggravators. And I'm going to explain it. And then we have the crime itself. So essentially what we have is these two prior violent felonies, battery on a Leo, and he was on probation. Well, that's a separate felony. He's on probation. Battery of a Leo is one violent felony. And then you have everything from this case. And so essentially the way it works is, in Miss Dixon's murder, you get to consider the prior convictions of the other events that you guys decided on. So you decided on 2 murders. And so what happens is, in Miss Dixon's case, that one murder falls into a prior violent felony. The shooting of Ronald falls into prior violent felony. One aggravator, but you get to look at the weight as these kind of generate and stack up. And the 2 shootings that involve Dominique and the mom. Those are all the felonies here. And that's going to become important when we talk about sufficiency. Because sufficiency is going to be the question, do I believe in this particular case, after I hear all the evidence and weigh everything out, that this is really a death penalty case? Or is there something else going on here? Was this decision made for some other reason? Do I feel that this should have been the death penalty case after I hear all the aggravation? That's the step before you even get to the weighing process. And we'll talk about that more. But now I want to go back to this period of time leading up to the events that transpired on the 13th. Who was Mr. Loyd? In mitigation, you get to consider everything about his life that you believe was proven to you by the greater weight of the evidence. And it could be as simple as this, folks. You know, we're not putting you in cubicles back there, and you all promised me you would make individual decisions, that there would be no bullying, that you're not going to go back there and go, I think it's a death penalty case, change your mind. Or on the alternative, I think it's a life case, change your mind. You're not going to have to do that. You can go back there and sit around the table and talk for hours if you want. But at the end of the day, it's up to you, and you, and you, and you, all of yous. And you can literally say, under the laws that exist, that I don't find that the aggravating circumstances outweigh the mitigating circumstances. And more importantly, I believe that the love of his mother and the connection to the family and the importance of Markeith Loyd to him and to the family, that mitigation in and of itself is sufficient for me to vote for life. And you know, because we talked about this every time I spoke with you as individual jurors, that you never, ever have to vote for the death penalty. You have that in instruction. You're never compelled to vote for death. So if you have a moral, personal, otherwise humanistic desire, and that the aggravators in your mind, your human mind, outweigh the mitigators in your human mind, that you never, ever have to vote for death. that you can walk into the light. You all have that personal choice to walk into the light. And it would be lawful. It's a really important thing we have in Florida. You all said you believe the death penalty. There's people who don't believe the death penalty. But the legislator has said you can walk into the light. It's your decision. So let's get back to the importance of this 13 seconds. At 7 years old, he's being raised on the streets, kind of, helping his family, loving his family, stealing for his family. Did we come in here to make his mother look like anything less than she is? A loving mother who did her best. African-American woman raising children in Carver Shores by herself. That's a lot of responsibility, and she had 5 children. She's doing the best she can. And this thing he talks about, we're making excuses because of the switches and the beatings and all that stuff, that was what she knew. And was that significant in this case? No. You even heard Dr. Campbell say that our client didn't believe that it had anything to do with post-traumatic stress. But the doctor is in a different position because that's only a consideration. See, we become who we are because of our experiences. Some of us have really good ones. Some of us have really bad ones. Some people have, as Dr. Dunn said, a person who comes into our life that changes us, a grandmother, an uncle, a family friend, who guides us away from the streets, away from the drugs. And racism has been talked about liberally through that case. 2019, folks. Where are we today in this community? Are black young men being treated differently than they were when he was growing up? Do they have more opportunities? Maybe. Maybe we are an evolving society. I'm not here to judge that. He calls it a phenomenon. It's a phenomenon? Racism phenomenon? It's a horror. I don't know. I mean, literally, I'm white. I didn't grow up in the environment that Markeith did. And some of you who are black may not have either. Sometimes it's who our father was, our grandfather, opportunities, working hard, whatever you want to call it. But at the end of the day, racism affected Markeith Loyd. Now, they want to draw into this argument that when he pulled those guns out, what did that have to do with racism? Nothing. Maybe. Maybe. I mean, let's track it back. Let's track it back to when he was 13 and he got his butt kicked on the basketball court. When he was 16 and he was attacked and kidnapped, which they tried to say, I think they were saying, can you believe it? There's all kinds of contradiction. 2 days, 4 hours. Witness after witness testified about his appearance and that the police wouldn't do anything. Failure of society. The police didn't do anything in that case. And so what we're hearing here is these are things that Dr. Campbell looks at when he starts evaluating trauma. He wants to know of events that are tied to concrete experiences that cause someone to be traumatic or suffer from trauma. And so what do we have here? at the very least, because we didn't hear everything, we know he was stabbed in prison. In his heart, he almost died. You heard that testimony from 2 witnesses, family members. Stabbed in prison. This is before the release in 14. 16, he was kidnapped. 13 had this event on the basketball court. He witnessed before his cousin Wesley. He was there right after the murder and said, you know, put a blanket over him. He's dead, and he's having this experience about put a blanket over him. And then after, a co-worker at the chicken place is robbed and killed. And then he's robbed twice. So as Dr. Campbell testified, he didn't bring up any of that stuff, by the way. I was waiting for him to kind of, all right, folks, I'll be honest, there's 5, 6 events that were traumatic. Understand what the doctor's saying. This is kind of a Pritchard thing. This is what they bring in Pritchard. Personal responsibility. He wasn't mentally ill. He wasn't delusional. 3 of my doctors, triple board certified neuropsychologists who did a test, who did the test. Do you have that, the chart? The graph? Thank you. Oh, thank you. Who did the MMPI-2, which Pritchard completely disregarded, didn't even really acknowledge. And you saw the exchange, and I apologize if I came off as being righteous with Dr. Pritchard. But you know, the bottom line is, he came in deposition, and he lied. He tried to say, well, I didn't think it was that, I thought it was this. Did you review the raw data, in this particular case from Dr. Sesta? Oh yes, I did. And then I asked Dr. Sesta about this, and these gentlemen went in the hallway, told him about it. Pritchard came up with some kind of, you know, excuse that he could use on the stand. That all played out in front of you. You may not put it together, but I'm the one who asked Sesta about that raw data. And he said he never sent it to him because he never responded. He has a password that he puts it in. And so, oops, I got caught. See, I'm not Perry Mason. I can't go, you're lying, doctor. Absolutely. The state pays me a lot of money. I really don't care whether a person gets death or not. It doesn't matter to me. All I care about is being their person so I can keep getting work. And I know really how to come in there and tell my story without any support behind it. I'm good at that because I practice at that all the time. That's why the state pays me the kind of money they do. So doctor, you're disagreeing with, let's see, you're a psychologist, right? Yes. Board certified? No, I didn't want to waste money on that. No. Are you a psychiatrist? A medical doctor like Dr.? No. Neuropsychologist? No. Community psychologist like Dr. Dunn? No. A trauma specialist? No. But I disagree with all of them. And my opinion is that, you know, he has some kind of personality disorder. Because that's what the state wants to say so they can get up here and do what this gentleman just did. There's nothing wrong with him. He's got a personality disorder. But guess what? Problem, Doc, problem here is that there is a concrete test that is well known that establishes that he has a psychotic disorder, a delusional disorder. And Dr. Mayer, a psychiatrist, Dr. Dunn, a community psychologist, and our neuropsychologist, Dr. Sesta, all agree that there's a psychotic delusional disorder. Now, they disagree on what it is. And as you listen to Dr. Mayer, he told you that there's a spectrum within the psychotic disorders. Schizoaffective, schizophrenia, bipolar illness. Dr. Dunn believes, based on his meetings, and I think he met with him the longest out of all the experts, because remember, Dr. Sesta met with him a couple hours, but he had grad students actually doing the testing for him. And then he ultimately had it scored. And these neuropsychological things were normal, fairly normal. He had a low average IQ, but the neuropsychological has to do with brain damage. And even though we had evidence of a history of brain injury, the neuropsychological tests show that he did not have any brain damage. Now, he tried to confuse you on that issue because brain damage is different than mental illness. Mental illness is not brain damage. Mental illness, as you heard from at least one of the doctors, is we don't know the origin. Sometimes it's biological, sometimes they don't know. But we do know, unrefuted, that his son suffers from schizophrenia and is hospitalized. So we have a mental illness that's diagnosed through 3 different doctors. The mental illness is psychotic delusional disorder. Dr. Mayer says it's psychotic NOS. You heard about something called the DSM-5. It's a book that these doctors use to diagnose people. And so under the spectrum of psychosis and psychotic disorder, there are different types. And Mayer says it's psychotic NOS. Dunn says it's schizophrenia, and Sesta says it's delusional disorder, psychotic spectrum. So we have 3 of the 4 doctors whose focus was his mental illness coming up with the same thing. The same thing. And then we have Dr. Campbell, who says that it's a problem if you have post-traumatic stress syndrome and you have psychotic disorder of some sort, delusional disorder, because that's called comorbidity. That means not only is he sick, but he's sicker. He's got 2 things pulling at him. So let's go to the 13th. Undisputed, I guess, to the extent of us getting to a place where he has 3 guns on him. A brother is there. There is this exchange going back and forth between Miss Dixon, and she makes this comment about, my brother's going to kick your ass. So, let's talk about someone who's delusional, who's paranoid, and who suffers from post-traumatic stress. Where is their mind? Before he even arrived there, he's carrying 2 guns. Not 1, 2 guns. He had been robbed on 2 occasions. The police were called on 1 occasion. The detective knew about that. I asked him when I called him as a witness, I asked him about that. He knew about that. So when he's arriving, where is his state? Where is his state of mind? And then he gets called over, or whatever you want to believe, he ends up with her gun. So at some point, he has a gun that she had. How it takes place, that's up to you. The only testimony, and it was unrefuted in their argument, the only testimony was that on the side of the house, he draws the guns out, she pulls it out, drops it, he grabs it, it sticks it in his pocket. That was not argued against by the state. So now he had another event bringing him up in his mind. And so now he's back over on the side, and the brother comes out. So he's had these events, the brother's out. Whatever he's thinking about the brother, he's thinking about the brother. But while he's there, she says, my brother's going to kick your ass. Boom. Mayor told you, without question. His state of mind at that time, his belief, his state of mind, he didn't say he was relying on his story, because I intentionally avoided his story, because when you came back with guilty, you rejected it in some form or fashion. So I'm not going to put myself at odds with you as jurors. I want you to see what I believe the truth is. And I don't want to take from you what you believe the truth is. So at some point, his state of mind is hypervigilance. It's dark. You heard the trauma testimony. These statements are being made. This stuff had happened. The events leading up to this. And what does he do? And so now you are looking at that 10 or 12 or 13 seconds through a different type of prism. And the prism only has to do with the aggravating factors. You get to use this all as mitigation, and I'll talk to you about it in a minute. But now it becomes the weight of the aggravating factors as you look through that prism. Because if you thought before, like, he was mad, he was angry, you know, he was pissed at her, and that's why he did this, you didn't know anything about his state of mind, and an opinion by a psychiatrist who says that based on everything that he knows about his mental health issues and the trauma issues, that he believes his state of mind was impaired. His state of mind was impaired. Not to the extent that it's an excuse. He's guilty of first-degree murder. You did the right thing. It's now an issue of impairment in regards to the weight of the aggravating factors. Impairment as to the weight of the aggravating factors. And then so those moments when he's reacting, what you thought was he was mad at her, she was leaving him, and she was eating meat, she was smoking, whatever you thought, now I am throwing into the mix for you and your consideration the delusional disorder and the post-traumatic stress, all of which would explain why he reacted. An alternative. Because for you to put it together the other way, you would have to actually make some leaps that you don't have to make with mine. You would have to make leaps like, I heard this guy, he's controlling. I heard this, I don't like this guy. You know, he was this way. He was physically abusive to her on at least one occasion. All these leaps that you could have made, which may have been justified at the time with believing Ronald. Why would that young man lie? Why would he make this up? Why would, you know, what the fuck? Why would the mom, you know, make that up? Even though Daniel said it was Markeith, I'm going to discount that, or I have an explanation for that. Whatever you concluded before is fine. I'm not stepping on that. All I'm asking you to do now is look at what we have here, and that is this issue of his state of mind at the time in these 13 seconds. Can you get the board for me? Thank you. The whiteboard? Yeah, thanks. Yeah, that's perfect. Thank you. You know where the All right, so let's talk about the verdict form that you're going to get. So essentially, the first thing that you're going to have to decide is whether one or more of the aggravating circumstances were proven beyond a reasonable doubt. I am conceding that all of the aggravating circumstances were proven beyond a reasonable doubt, and I'll tell you why, okay? So the first one is that he was on probation. No question, he's on probation. He goes to federal prison. Well, he goes to prison first for 4.5 years, and at the same time he's sentenced on the federal prison drug count, and he does the 14 years. And so when he gets out, he moves into a halfway house. He's on probation. You heard from the probation officer who said he was doing everything that he was supposed to do. I think he tested twice positive for marijuana, and I think there was a car accident or something that he was involved in that he didn't report, but they never violated his probation. He was on probation at the time. Now, I put in front of you, and again, I'm not asking you to believe or disbelieve anything. What is important is when you are thinking about Markeith and who he is, you have to consider his experiences. Now, let's be frank. If you believe, and put aside his testimony for a second at trial, because I don't know what you found or how you found it or whatever. But if you believe that Markeith was victimized by that police officer, was targeted by that police officer who stopped him for a traffic stop, who took Markeith's wrist, which was damaged, which you heard testimony about, even after he told him to stop, and continued to cause him pain, that Markeith was justified for striking him because of the aggressiveness of this officer, and then going to trial and getting 4.5 years for something that he shouldn't have been convicted of, because you heard he went to trial, and you heard that he testified at trial, and the officer testified at trial, and you know, I don't know how to say it any other way. This is a white officer, and he's a black drug dealer. So, I mean, and you see how Markeith looks. Imagine how he looked back then. I mean, so let's assume that you believe that he should have never went to prison for that. That was just crazy. You get to give whatever weight you want to that aggravating factor. You can, because the aggravating factor of battery on a law enforcement officer is proven, okay? So the second set of aggravators are prior violent felonies. Okay, we can go through. So the first one is battery on a law enforcement officer. So you get to give whatever weight you want to give that one. Period. End of story. Let's jump up to probation. He was on probation at the time. Undisputed. I heard it. It ringed in my ears. No questions. Sir, whose drugs were those in Mr. Loyd's house? They were mine. He went to prison for 14 years, and he told the experts this. He went to prison for 14 years because he didn't want the girl he was with at the time to take a hit on the drugs. That's the aggravator they're using. Did they ask any questions of that witness? There was 2 or 3 witnesses who said they weren't his drugs. Now, in the world we live in, we're law-abiding citizens. Are we thinking, yeah, but he was a drug dealer? He was a drug dealer. He sold drugs from the time he was 16 until he was 22. He's on the street selling drugs. Maybe it wasn't his that time. But, you know, what comes around goes around. You can think that way. Or you can think, I don't believe those guys, even though they came in and told their truth and was never challenged by the prosecutor. Or you can believe, yeah, he went to prison for a very long time for something he didn't do. Does that happen in our country? Does it? You can allow your anger and your hate, whatever you feel towards Markeith, to roll with you, or you can just say to yourself, I'm going to keep an open mind. And so guess what? You can get to give whatever weight you want to this prior fact that he was on probation at the time. Now remember, factually what had happened was he's on probation. He tells, I don't remember who he told, but he told someone, I want to try to make a change. And he wants to make a change. So he gets out, he's in a halfway house for a while, and then I think he lives with his sister for a while, and then he gets his own place, and he's working 4 jobs at one time, and then he's working at the chicken place all the time, you know, from whatever time till 3, 4 in the morning, making deliveries, making decent money. He's got people living in his house. He's trying to make a start. He wants to start a family. You saw some of the Facebook stuff that was presented to you. He wants a family, and that's how he started in the relationship with Sade. Now you can judge from your perspective as jurors anything you want about him. The way he talks, the way he talked about her, his discussions in regards to her not smoking pot and eating meat, control issues, whatever you want. And Dr. Dunn does say he has control issues. There's a lot of people who have control issues in our society. Probably people we know who are close to us. Doesn't mean that you're a murderer, okay? He committed murder, there's no question. We're not saying that. What we're saying is that there are circumstances that led to this that we have to consider now in terms of whether life or death is the appropriate sentence. So you can give whatever weight you want to that. Now the other prior violent felonies are all related to the case, okay? So the way it works is you have 2 verdict forms. You have one for the child, the fetus, and then you have one for Ms. Dixon, okay? And so under the PVFs, it's going to be whatever murder occurred in the other one. So in other words, in Sade's case, you're going to get to use the child killing as or the fetus killing as an aggravating factor. Then you're going to get to use Ron's, Daniel's, and Mom's. Then you get to use those as the prior violent felony. Now this is one aggravating factor, but now you got to start looking at the weight that you attach to it, okay? And so this is what becomes important with his state of mind in that 13 seconds. And I'm saying 13 seconds. It could have been less. It could have been more. I'm estimating based on the number of shots and how quickly it took place and people hearing the shots. Boom, 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 boom. Whatever that is, that's a factual thing for you to consider. But now you get to consider his state of mind when you're looking at the weight that you should give those aggravating factors. And I would suggest to you that you have to really take away what you may have thought at the beginning. Now, certainly, premeditation is an issue that occurs instantaneously. And we're not saying that he didn't think about pulling the trigger and doing it. Now we're saying what led up to this internally that caused him to react in the way that he did. Delusional disorder, post-traumatic stress disorder, combination of both, life experiences, and the trauma issues are all about what we had talked about, stuff as a child, coming up after he gets out, and the robberies, all that stuff with this diagnosis where Mayer's saying something is causing this to happen, and that's where you get to consider those factors. And then finally, the third factor that you can consider is the fetus. Now, you guys scrutinize the if I can in a second. You guys scrutinized the jury instructions because we were waiting out here when you guys were going through that stuff. And now you get left with something even more difficult to deal with, in my opinion. And so here's the factor, what we're talking about with the child. Or not the child, the fetus. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factors that Sade. I think this is incorrect. I thought it was supposed to be person. Did you read the? Is it in the jury instructions?
It's in the jury instruction.
Okay.
It's also in the verdict form.
Okay, I'm sorry. I misread it. Okay. So here's what I'm talking about. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Sade Dixon's unborn child was a person less than 12 years old. And so now you get, not with the fetus, unborn child, it's a person is the definition that you're given within the jury instructions. I would suggest that there is no guidance that indicates to you whether a fetus is a person or not, and that's an individual decision. But even if you decided that it was a person, was he shooting her with the thought of doing this? This goes back to this issue of hypervigilance, post-traumatic stress, and the thoughts that are associated with this delusional disorder while this is acting out. So you get to give the weight on that one, but it's only on the count with the unborn child, not the Sade Dixon count. These are the aggravating factors, folks. This is what you look at in terms of the aggravating factors. Can you put that up on the screen? All right, so here are some of the mitigating factors that you get to consider. And I talked about a lot of these. Is that the whole list that you have? Okay. So I'm going to leave that up for you if you want to write it down or whatever. But essentially, when it comes to the mitigating factors, and we're talking about the mitigating factors here, the same things that were addressed with his state of mind, his mental illness, his delusional disorder, all those factors are things that can be considered as mitigation separate. So when I talked about this event transpiring, that has to do with the aggravating factors and mitigating the weight of the aggravating factors. Now I want to step away from that, because that's for your consideration, and I want to talk about the mitigating factors. The mitigating factors are the same when it comes to the circumstances of that event, but has to do with his life. Because if you look at the jury instruction reads that you get to consider, make sure that I read this correctly. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may reasonably indicate that the death penalty is not appropriate. I spent this time now talking about the circumstance of the offense and as it applies to aggravating factors. Now, on the other side, you get to consider everything that you've heard about his life from the beginning, and I'm not going to, berate what was talked about. You guys were present when this happened. From the beginning that he was born, he didn't have a father. He was raised with no father. He had a mother. They struggled. They didn't eat. They raised in an environment that was poor. They loved each other. The discipline that he dealt with, getting tossed in the streets, and he became a drug dealer, He went to a hospital, and they allowed him to check out. His mom allowed him to check out, so he never got the treatment that he needed. You know, the school system failed him, as you heard from Dr. Mayer. There was failure after failure after failure, and then he went to prison. And, you know, all of those things you get to consider. And when he came out, and he's trying to make it, you know, make it better for himself, and he has a loving relationship with his family, and he has a loving relationship with his daughter, and he has a loving relationship with his granddaughter. I mean, you saw the videos. He's a human being. He deserves to live, not die. And so when you look at the mitigation that you're talking about, you get to weigh all the mitigation that was presented to you. And you, as a juror, get to decide what's important to you. And you can consider it individually, collectively, whatever way you want. You may think that the delusional disorder is something that's really important to you, or maybe an accumulation of his life experiences and the trauma that he suffered, and the diagnosis that we have here, and that he's a good grandfather. Being a good grandfather, having a grandfather around who can be there, that could be enough for you as an individual juror. That's all you need. There are no rules. You get to decide what mitigation is important to you and how to use it. And you don't have to talk about it. You don't have to discuss it. You don't have to justify it. I know you guys have been together for, you know, it seems like forever, but you don't have to share what you feel. All you have to do is say, I'm voting life. I'm voting life. All it takes is one of you, one person, and nobody's going to know who or how many or anything. What was this, Judge, the verdict form, that doesn't include that, right? Correct? I forget because it's changed.
It does.
It does not?
It doesn't.
Okay. Just want to make sure. So you don't have to justify to them or them or them or anybody what your personal opinion is and what your personal finding is. But what we do know is that your verdict brings closure to this case. There's another case out there that you have nothing to do with. And you know you can't have anything to do with that. And you won't have anything to do with that. That's not this case. That's what you heard here in the courtroom from the witnesses and the evidence that was presented to you. Now there's one more point I wanted to make to you, and that is sufficiency of the aggravation. And we started out talking about sufficiency of the aggravation. So once there's a determination that the aggravation has been proven, at least one, beyond a reasonable doubt, and I concede that. I concede that the aggravators have been proven. I disagree with weight. I believe that you should give them little weight based on what I've argued. But I concede that there's no reason not that the aggravators have been proven. The next step is sufficiency. And it's entitled in the verdict form, sufficiency of the aggravating factors. It's subsection B. And so what it says is, reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt in section A above, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible death sentence. If you believe that the aggravating factors are not sufficient to warrant a death sentence, you must check no. And so that ends everything. You don't go on and weigh the aggravating factors. You don't go on and weigh the mitigating factors. All it takes is one of you to say, I don't find that the aggravating factors warrant a possible death sentence, and the case is over. If you go on, then you go on to the aggravating factors, you go on to the mitigating factors, then you go on to the eligibility factor, and then you go on to the verdict factor. So to get to the verdict factor, You must have found that the aggravating factors outweigh the mitigating factors. All of you, collectively, all 12. If one of you says no, the mitigation outweighs the aggravation, then you're done. But even if you get to the point, and we talked about this in jury selection at length, even if you get to the point where you believe that all 12 believe that the aggravating factors individually outweigh the mitigating factors, you still do not have to vote for death. Period. End of story. That's the law. It's in the instruction. You are not required to vote for death. It has to be unanimous for a death verdict to take place. The evidence in this case became a different journey in this part. And I apologize for anything I may have done to step on your opinion or your verdict in this case. That was not my intent. My responsibility has always been to Markeith and to make sure that you as individual jurors know and understand who he really is, so that you can make a decision that is just for yourselves and for who you are and for what you believe. And I ask you, I beg you, please step into the light. I'm done, Judge.
Thank you, Mr. Lenham.